The moment your attorney signs and sends the demand letter, the nature of your claim changes from a conversation into a legal confrontation. Most injury victims view this document as a simple request for payment, a formal way of saying they want to settle. They are catastrophically wrong. The demand letter is not a request. It is the formal opening salvo of litigation. It is the document that puts the insurance carrier on legal notice that you have finished your medical treatment, you have calculated your economic damages, and you are officially demanding compensation under the threat of a lawsuit. If your attorney writes a weak demand letter, you have already compromised your leverage. If they send it before your medical record is fully developed, you have invited the insurance company to undervalue your claim by 50% or more, because here is the reality most victims never see. The demand letter is the roadmap an adjuster uses to determine if they should fight you in court, or pay you what the case is actually worth. By the end of this episode, you will understand the anatomy of a strategic demand letter, why timing is the single greatest factor in its success, and exactly what your attorney must include to force an adjuster out of their playbook and onto the negotiating table. Welcome to Torts and Truth. This is your decoded advocate. If this is your first time here, subscribe right now, because what follows will permanently change how you evaluate every legal decision made on your behalf. The anatomy of a strategic demand. An amateur demand letter is a cover letter attached to a stack of medical bills. A strategic demand letter is a comprehensive legal brief that tells a compelling, undeniable story of liability and damages. It is structured to make the adjuster's job difficult if they choose to deny it. First, it establishes liability, not just by claiming the other driver was at fault, but by citing the specific traffic statutes they violated and presenting the evidence that makes the defense's position untenable. Second, it details medical treatment in a way that correlates every single appointment, every physical therapy session, and every diagnostic scan directly to the injuries sustained in the accident. If the adjuster can argue that your medical treatment was unrelated, excessive, or unnecessary, they will. A high-level demand letter closes those gaps before the adjuster can even open them. Third, it quantifies economic damages, meticulously detailing medical expenses, lost wages, and out-of-pocket costs. But the real power lies in the final section, the calculation of non-economic damages, pain, suffering, loss of enjoyment of life, and the permanent impact of the injury on your daily existence. This is the most subjective part of the claim, and it is where a seasoned attorney provides the institutional justification for a high-value settlement. The adjuster's playbook vs. your roadmap. When an adjuster receives your demand letter, they do not just read it, they input the data into their software, a proprietary algorithm designed to minimize the payout. That software relies on specific data points: the duration of your treatment, the nature of your diagnosis, the reputation of your attorney, and the strength of the evidence presented. Your demand letter is the only opportunity you have to provide input into that calculation. If you send a thin file, they will calculate a thin settlement. If you send a thick, evidence-backed file that demonstrates a clear path to trial, their software recalculates. Insurance adjusters are not incentivized to pay you fairly. They are incentivized to close files at the lowest possible cost. A strategic demand letter changes the economics of the file. It forces the adjuster to consider the cost of litigation, the hourly rate for defense counsel, the cost of expert witnesses, the risk of a jury verdict, and the internal administrative costs of a long drawn-out case. When the cost of fighting you exceeds the cost of paying you, the dynamic of the negotiation shifts in your favor. The timing trap. Why rushing destroys value. The most common mistake injured victims make is pressuring their attorney to send the demand letter too early. They want the case over, they want the money, they want to move on. This is a strategic error of massive proportions. If you send the demand letter before you have reached maximum medical improvement, the point where your physician determines your condition is stable and permanent, you are effectively capping your own damages. You cannot claim for future medical expenses if you do not know what they will be. You cannot claim for permanent impairment if the physician has not documented it. Adjusters love early demand letters. They know that an incomplete medical record is an incomplete claim. They will offer a quick settlement based on the partial records they have. And once you sign that release, you are barred from ever coming back for more. The demand letter should only be sent when the evidence is unassailable, when the medical records tell the full story, when the prognosis is clear, when the documentation is ironclad. The correlation factor. This is the technical element that most claimants fail to understand. Your medical records must correlate to your accident. If you have a history of back pain and you hurt your back in an accident, the adjuster will claim it is a pre-existing condition. If you wait 2 months between the accident and seeing a doctor, the adjuster will claim the injury happened elsewhere. If you miss physical therapy appointments, the adjuster will claim you were not really hurt. The demand letter must anticipate these arguments and refute them with evidence. It must show that your injuries are not just related to the accident. They are clearly and unequivocally caused by it. It provides the medical evidence, the physician's testimony, and the supporting documentation that makes it impossible for the adjuster to deny the causal link. This is where the skill of your attorney is most visible. They are not just summarizing your records. They are actively fighting the insurance company's inevitable arguments before they are even made. The psychological leverage. Demand letter is not just a document. It is a threat. It is a subtle, professional, and institutional threat of trial. It tells the insurance company, we are prepared, we have the evidence, we have the expert witnesses, and we are ready to take this case in front of a jury if you do not pay the fair value of this claim. Insurance companies do not fear the attorney, they fear the jury. The demand letter is the first step in proving that your case is jury ready. Every photograph, every medical report, every witness statement included in that letter is evidence that will be presented in court. When the adjuster sees that level of preparation, they understand that you are not looking for a quick, cheap exit. You are looking for justice, and you are prepared to secure it. This is the leverage that drives settlements above the policy limits. It is the leverage that forces the insurance carrier to bring more authority to the negotiating table. If you missed our last video on the test every malpractice case must pass, the link is in the description below. Watch it after this one. This is your Decoded Advocate, and I will see you in the next one.